Hey, it's Terry Gorry, and this is the Irish Law and Small Business podcast. In this video, I want to discuss again a very, very common mistake that I see employers making time after time after time to do with unfair dismissal. This case will illustrate precisely the mistake that employers make, and I've made many videos about this, pointing out various cases where the employer made the mistake and they lost an unfair dismissal claim, and it cost them significant sums of money. In this particular case, it involved an employee working for the Carlow Dental Centre. The employee in question, Irene Glynn, was alleged to have made a Facebook post which had what the employer viewed as hate speech. So the worker was sacked because her bosses believed a Facebook post that she made linked her to criticism of Ukrainian refugees coming to Ireland for leaving the war zone, etc. And she brought a claim for unfair dismissal arising from her dismissal. The employee, Miss Glynn, Irene Glynn, said that her employer, the Carlow Dental Centre, gave her no opportunity to defend herself or explain herself, etc. She submitted in her submission to the WRC, the Workplace Relations Commission, that for all the employer knew, her account could have been hacked. The WRC found that the dental centre, Carlow Dental Centre, had failed to investigate the allegation against Miss Glynn, and the matter could have perhaps merited a warning rather than a dismissal. The tribunal upheld Miss Glynn's complaint for unfair dismissal, and she was awarded €10,500. The Facebook post in question was, "Ireland is on its knees. Irish working people can't afford heating or food, yet refugees think it's a free-for-all. Stay, fight for your country. Our grandparents fought against the English. Do the same," read a screenshot of an alleged comment on the Irish Supporters of Ukraine Facebook page that was submitted in evidence. The screenshot had been sent to the clinic, the Carlow Dental Clinic, by a member of the public who was critical. It said, "Your staff have very extreme views when it comes to refugees coming into Ireland," the tribunal was told. The clinic's position, the employer's position, was that it had zero tolerance towards any written or spoken hate speech, racial remarks, or anything that could cause any incitement towards minority groups. A text from a manager asking Miss Glynn to take down the post was met by a reply from Miss Glynn's partner, who with an instant denial. And the partner told the clinic not to text the complainant's phone again. The complainant said she was out on certified sick leave when the text came, and that her partner had her phone on the day in question. The owners of the business met with senior managers the following Monday, January the 9th, and sacked Miss Glynn for what they viewed as serious and gross misconduct, taking the view that the post was, quote, hate speech as defined by the Prohibition of Incitement to Hatred Act 1989. Miss Glynn said she got no opportunity to defend herself before being told that she was sacked. She said she was not a member of any political group and that she was free to share her opinions and was entitled to freedom of speech. She said that she was not told at any stage to stop posting on social media, and that her account could have been hacked for all the respondent knew, adding that the member of the public saw and reported may not have been a posting that she made. A witness for the employer gave evidence to say that said that there was nothing to investigate in relation to the post, as it was there for everyone to see. So this is the crucial mistake made by the employer. There was nothing to investigate. In other words, based on the post that was there to see by all and sundry, the employer made the decision to dismiss. This was the mistake. No procedure, no fair procedures, no natural justice. The witness had decided not to reprimand the complainant for these views, given the very fine line when it comes to an employee's private social media page. The witness said that she was aware that Miss Lynn had strongly negative views on immigrants, which she posted on her private Facebook page. So the employer was aware of Miss Lynn's negative views on these matters, but hadn't done anything about it. The witness said that Miss Lynn was sacked because her alleged conduct warranted immediate dismissal and denied that other factors were involved. In her decision, the adjudication officer said that while every person has the right to freedom of expression, this right is not absolute. She noted the evidence of the employer side witness that she knew about Miss Lynn's social media posts regarding immigrants. So the employer knew about these posts or similar posts in the past. Yet, according to the adjudication officer, she never thought to draft a social media policy. So no policy from the employer. And that was a big factor in this decision by the WRC. Miss Deering, that's the adjudication officer, wrote that the onus was on the employer to prove that there had been substantial grounds for dismissal, but that it did not conduct any form of an investigation or verify how the post came to its attention. The complainant's alleged comments merited the respondent's attention and perhaps a warning to desist or exercise caution in posting, but they did not constitute gross misconduct. The adjudication officer awarded Miss Deering, or Miss Lynn rather, the employee, $8,500 for unfair dismissal, and also ordered a further 4 weeks notice pay of $2,000 under the minimum notice legislation, bringing the total cost of orders in the case to €10,500. So that's what the employee was awarded. On top of that, then, if the employer had solicitor or legal representation involved, then there's extra costs for the employer. And all of this could have been avoided if the employer had used disciplinary procedure in the workplace and had investigated thoroughly and had then put the allegation to the employee and given the employee the opportunity to respond to the allegations. If the employer had done that, and if the employer had then come to a fair decision based on the evidence and based on what the employee had to say in defence, well, then the employer would be in a far stronger position. Now, the adjudication officer opined that perhaps the issue might have merited a warning, but it's not for the adjudication officer, quite frankly, to substitute their judgment or their view for that of the employer. So had the employer gone through a proper procedure, it's possible that the unfair dismissal may have been upheld. Who knows? I don't know whether the Carlow Dental Clinic are going to appeal this decision or not to the Labour Court, but they will face precisely the same problem at the Labour Court. That is, what procedure did you use? Did you afford fair procedures and natural justice to the employee? And the answer from the evidence from the WRC case appears to be no. This is the mistake that employers make repeatedly, time after time after time. If you are an employer, no matter how bad you think the conduct is, no matter how odious you think the speech is, no matter what the employee does, you really do, in order to cover yourself, go through a procedure. You must go through a procedure. Hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below. Thanks a lot.